In chambers, tonight the Supreme Court hears Gideon versus Wainwright. The question, when a man too poor to hire a lawyer is put on trial for a felony in a state court, and he asks that an attorney be appointed to defend him, does the Constitution require the state to provide one, or may he be made to stand trial alone? What follows is the verbatim oral argument. You may be seated. Argued January 15, 1963. Chief Justice Earl Warren presides. For the petitioner, Clarence Earl Gideon, Mr. Abe Fortas. For the respondent, the State of Florida, Mr. Bruce Jacob. Mr. J. Lee Rankin appears for the American Civil Liberties Union as amicus curiae, and Mr. George Mentz for the State of Alabama. Chief Justice Warren. Number 155, Clarence Earl Gideon, petitioner versus H. G. Cochran, Director, Division of Corrections. Mr. Fortas. Mr. Fortas. Mr. Chief Justice, may it please the Court, this case is here on writ of certiorari to the Supreme Court of the State of Florida. In issuing the writ of certiorari, this court expressly requested counsel to discuss the following question. Should this court's holding in Betts v. Brady, 316 U.S. 455, be reconsidered? The question, of course, is the right of accused in state criminal proceedings to the appointment of counsel, specifically in the present case which you have before you. The question is an exceedingly narrow one. The question in the present case is whether requests being made by the accused that counsel be appointed to him, the accused being concededly indigent, it is the duty of the state to accede to that request and to appoint counsel for purposes of assisting the accused in the trial of the case. In other words, the present case involves a trial, a plea of not guilty. It involves a felony. And that is the narrow question that this case presents. Clarence Earl Gideon was convicted by the state of Florida for the violation of a statute which makes it a felony, unlawfully and feloniously, to break and enter a building of another with intent to commit a misdemeanor. He was charged with breaking and entering the Pearl, the Bay Harbor pool room in the city, in Panama City, Florida. And having broken and entered that pool room, he is charged with having extracted some wine, perhaps some cigarettes, and a sum of money. There is no evidence in the record as to the amount, but the amount must have been less than $100, because the statute of the state of Florida defines petty larceny as the taking of goods or money in an amount less than $100. Justice Harlan. Betts and Brady did not proceed on that basis. It did not deny the obvious. Obviously, a man is not represented, who is not represented, who is not hasn't had as good a shake in court as the man who is represented. Betts and Brady didn't go on any such basis as that. Mr. Fortas. Are you suggesting, Mr. Justice Harlan, which I believe to be the case, that the real basis for Betts against Brady is the following: that a man does not get a fair trial if he is not represented by a lawyer, but that the demands of federalism outweigh the absence of a fair trial? Justice Harlan. That's what I understood the basis of Betts and Brady to be, yes. Mr. Fortas. I read it as indicating both, but of course we must remember in reading Betts against Brady that Betts against Brady was involved a trial before a very distinguished jurist, Judge Bond of Maryland, and it did not involve a jury trial. Justice Harlan. Well, that isn't quite so simple as that, because under our concepts in the federal system, apart from the Sixth Amendment, we would consider that a man in a felony case hadn't had a fair shake if he wasn't tried before a jury. I suppose the state could do away with the jury trial, and yet you wouldn't say this trial was inherently unfair, would you? Mr. Fortas. That's right. Now that's what I want to get to, Mr. Justice. Justice Harlan. I think you got to argue this on the basis of federalism. Mr. Fortas. I appreciate that, and I am happy if we can clear the debris, if I may say so. We can understand exactly what is that issue here. Justice Douglas. Well, this federalism that Justice Harlan mentions is implicit, as I gather, in all that we have written. I believe I have read all of them, written some of them. I don't know if anyone has. Any member of this court has come out and said in so many terms it's the constitutional right of the state to provide a system whereby people get unfair trial. Justice Douglas. You mean if a person can't have a fair trial without a lawyer, and this is the problem of federalism, you come down to how a state has a constitutional right to provide a system that perpetuates unfair trials. Mr. Fortas. Mr. Justice Douglas, it seems to me that's perhaps the prop, that I would state the proposition in this way. And I do believe that it is a proposition that proves itself. That is to say, the 14th Amendment requires a fair trial. You cannot have a fair trial unless the defendant has counsel. Now, the QED to me is so obvious that I can't escape from it, and I can't escape from it by saying that the QED does not follow because of a principle of federalism. We start with the proposition that the 14th Amendment requires a fair trial, and we say that the defendant in a criminal proceeding cannot get a fair trial unless he has counsel. And it seems to me to follow without any possible escape hatch that he's got to have a fair trial. But I think I may be wrong about this, but I do believe that in some of this court's decisions there has been a tendency from time to time, because of the pull of federalism, to forget the realities of what happens downstairs, of what happens with to these poor, miserable, indigent people when they are arrested and they are brought into the jail and they are questioned. Justice Harlan, understandable sensitivity to describe a basic principle of our government doesn't seem to me to be a very happy expression. Mr. Fortas, well, I'm sorry, sir. I meant that a regard which I myself share for the principles of federalism, but I believe that those principles are misapplied here. First, they are misapplied, if I may respectfully say so, when they are used for the purpose of negating a 14th Amendment right to a fair trial. Secondly, they are misapplied here because a true regard, in my judgment, Mr. Justice Harlan, for federalism here means that this court will lay down a principle, will establish a principle, and that this court will not exercise the kind of minute, detailed, ex post facto supervision over state court trials that you have been exercising for these past years, in which, in my opinion, is the most corrosive possible way to administer our federal state system. And that it is I should like to restate that very simply and very plainly, Your Honor. I believe that Betts against Brady does not incorporate a proper regard for federalism. I believe that Betts against Brady, laying down as it does the principle of case-by-case supervision by the federal courts of state criminal proceedings, is antithetical to federalism. Mr. Fortas, now, of course, this is wrong, and it's wrong as a matter of federalism, because what happens is the following. Let's take a look at it. A defendant is arraigned. How can a judge, looking at the defendant, decide whether there are special circumstances in his case? Does a judge look at this defendant and say, "You look stupid. You look as if you are a moron"? Does he have a mental examination of him at the time? Does the judge or the magistrate before whom these defendants are arraigned on a typical day in court take a look at the crimes with which they are charged and say, "Now this one involves complicated questions of intent"? Mr. Fortas, that is this Brown brief, Mr. Justice Black, a brief for the state government, amici curiae. At the bottom of page 17 it says, "But it is difficult to comprehend how, as a practical matter, a trial judge can do this." That is to say, apply Betts against Brady with the degree of consistency presupposed by a judicial determination placing the onus of such decisions upon him. In the first place, in a felony case, it is highly unlikely that there is one trial judge as such. Mr. Fortas, that's correct. Yes, sir. So I believe that the fact of the matter is this. I think that we can confidently predict. We can confidently say that overruling Betts against Brady at this time is acting in accordance with the common opinion of those citizens of our country who are qualified to have an opinion. That's not always the case with respect to great constitutional changes. Justice Black, am I to understand that you think the Fifth Amendment's guarantee, or the Constitution's guarantee of the right to counsel, has nothing to do with this? It solely deals with due process. Mr. Fortas, no, sir, I certainly do not lay it aside, and you'll see in our brief that we argue it not, Mr. Justice Black, in terms of the argument that the 14th Amendment incorporates with respect to the states the provision of the Bill of Rights. Justice Black, how does the 14th Amendment do it? Mr. Fortas, 14th Amendment? Mr. Justice Black, I like that argument that you have so eloquently made time and time again. I can't make it to this court as an advocate because this court's turned it down so many times. I hope and pray that you will never cease contending for it. Mr. Rankin, Mr. Chief Justice, may it please the court, the amici urge the court to reconsider Betts against Brady and overrule it. We have carefully examined the federal question, and we do think that is the heart of the problem. But in the examination of that question, we think you have to start back to the Fourth, with the 14th Amendment and the question of due process and equal protection. And we think that the error in Betts against Brady is the basic assumption that you can have a fair trial in the ordinary circumstances, where you do not have special circumstances without a lawyer. There is where we think the error in Betts against Brady is, and that's where it needs to be corrected. Mr. Rankin. And it's rarely, as we lawyers all know, that a man does as well, because we have a saying, as you all know, that when he represents himself, he has a fool for counsel, and it's often true. Now there are exceptions, but I don't think the rule is sound when it's based upon the exception. It should be based upon the general rule that you can't have a fair trial without counsel. Mr. Jacob. Yes, Your Honor. Mr. Chief Justice, may it please the members of the court. I am Bruce Jacob from the Attorney General's Office of Florida, representing the respondent. With me at the counsel table is Mr. George D. Mentz, who is an Assistant Attorney General of Alabama. The state of Alabama has filed an amicus brief, together with the state of North Carolina, on our behalf, and Mr. Mentz has been allowed 20 minutes of my time. At the outset, I would briefly like to explain the procedure followed by the Florida Supreme Court when a petition for habeas corpus is presented to that tribunal. The Florida Supreme Court does not stand on formalities. Chief Justice Warren. And you had 8,000 prisoners, therefore 5,200 prisoners have not been represented by counsel in the trial court. And then I noticed also that ever since, in all the time following Betts and Brady up to the present time, there's only been one decision in your state courts finding special circumstances under Betts versus Brady. Mr. Jacob. Your Honor, there may be. I'm not sure of the cases, and there may only be one reported case that holds that, but many trial courts appoint counsel when they see special circumstances. This particular trial judge in this case misquoted the law on according to the transcript which has been filed with the court. He said, "Sorry, Mr. Gideon, I cannot appoint counsel for you except in a capital case." Now, on its face, that appears to be a misstatement of the law because Florida does follow Betts versus Brady, and in Florida, a man is entitled to counsel if he can show, if he is indigent and also he is ignorant, illiterate, or incompetent in some way. Since our brief has been printed, I have received a letter from the trial judge who handled this case. Justice Black, may I ask you why your argument of federalism doesn't apply alike to the Betts and Brady method of setting aside judgments and to the automatic method? Mr. Jacob, because, Your Honor, this court has power to review decisions of state courts when state courts have treated a defendant unfairly. Justice Black, as a matter of fact, one of my objections to Betts and Brady is that it does impose an unfair burden on the states in that it leaves them uncertain in every criminal case whether it will come up here and the facts will be viewed differently to the way the facts were viewed by the state courts. Mr. Jacob, Your Honor, I don't think Betts versus Brady is that unclear. I think it's inconsistent in the same way that the entire common law is inconsistent. Justice Black, well, how come most states don't know what circumstances will be held sufficient after we review them several years after your states view them? Mr. Jacob, each time this court decides a case, that adds a new special circumstance which we must consider in determining whether the defendant is entitled to counsel. Justice Black, what historical support do you find in history, back before the early days, for thinking that a man who is charged with a crime for which he might be only sentenced to life or sentenced to 50 years was any less entitled to a fair trial than the man who might be executed? What historical support do you find for that in your studies of history in this field? Mr. Jacob, Your Honor, I can't think of any historical. I'm not Justice Black, I can't either. It was the reason I asked you. Justice Black, I suppose most people are fearful about being put in jail, in the penitentiary too. Mr. Jacob, they are fearful of that too, but it's nothing like being put to death, Your Honor. Justice Black, are you arguing that we should draw such a line? Mr. Jacob, I'm arguing that you shouldn't draw such a line under the due process clause. But if you do, that is the logical place to draw it between capital and non-capital cases. If the Sixth Amendment as it's presently construed in Johnson versus Zerbst is to be incorporated or absorbed into the 14th Amendment, the rule would have to extend to all misdemeanors, because the Sixth Amendment just says in all criminal prosecutions the defendant is entitled to counsel. And of course, misdemeanors are crimes. Justice Black, what do you understand Johnson and Zerbst held with reference to that right? Mr. Jacob, Johnson versus Zerbst held that the Sixth Amendment meant you are entitled to counsel in every single case. Justice Black, without exception. Mr. Jacob, without exception, because the Sixth Amendment doesn't make any differentiation between different types of crimes. The main point, it seems to me, in the argument for the petitioner is that it's impossible to get a fair trial without counsel. That seems to be the main point that they rely upon. Mr. Jacob, that's precisely our point, Your Honor. Many defendants are smart, and it shows up every day in our handling of these habeas corpus petitions. Some of these men know exactly what they're doing, and there's no problem in raising special circumstances. This is the only petition I've ever seen where they didn't set out all the circumstances of the case. Usually they just go on and tell everything that happened. And usually it raises a question that must be decided by requiring a return and a hearing, in some instances. By imposing an inflexible rule in all criminal cases, we feel that this court would be intruding into a field that has been historically reserved for the states. Mr. Mentz, Mr. Chief Justice, may it please the court, in company with Florida, Alabama, and North Carolina, are of the opinion that Betts versus Brady should not be overruled. Regrettably, my presentation will in many areas duplicate that of Mr. Jacob, but fortunately, I'll be brief. We contend that the Sixth Amendment, providing for representation by counsel in criminal prosecutions, operates only on the federal government, that state appointment of counsel, in and of itself, is not an essential to a fair trial, that an asserted denial of due process should be tested by an appraisal of the totality of facts in a given case, and that the 14th Amendment's due process clause does not make the Sixth Amendment applicable to the states. Justice Black, maybe the states and the federal government shouldn't hire lawyers and prosecutors. Mr. Mentz, it will put us all out of business now if they do that. I agree with Mr. Jacob completely now when he says that Powell, although Powell is often cited for the proposition that as a mandatory rule that counsel be appointed in all capital cases, I don't find that in Powell. I think that Powell holds that under the facts of that case, there were special circumstances which required that counsel be appointed in order to meet the requirements of due process. Mr. Fortas, thank you, Mr. Chief Justice. The basic proposition that I believe the court has before it is a problem of constitutional statesmanship, perhaps, that this court has recently traversed in Mapp against Ohio. Mapp against Ohio, in my opinion, presented a more difficult situation, not an easier situation. I believe, to paraphrase Mr. Justice Clark's notable opinion in Mapp against Ohio, that time has set its face against Betts versus Brady. I believe, again to quote Mr. Justice Clark in Mapp against Ohio, and I quote, "Further delay in reaching the present result could have no effect other than to compound the difficulties in the future." I believe that that is the beginning and the end of the situation on the practical side of this case. Chief Justice Warren, Mr. Fortas, before you sit down, I should like to say this. This is a very important case. It's a very fundamental case. It's important to the state of Florida, to the state of Alabama, and the other states that have that same rule. It's important to thousands and thousands of poor litigants throughout our country. But as important as it is, I can't escape the feeling that in many of the cases of these indigent defendants that we're talking about, problems just as fundamental and just as important as this arise, and it shows what benefit we do get from counsel in deciding those issues. I want to say that we're always indebted to members of the bar who are willing to undertake cases of this kind as a public service, and we're grateful to you for having done so for this indigent defendant. We're very grateful to you, General Rankin, for having appeared as a friend of the court in the same cause. The court rises, the chamber falls silent. 2 months later, on March 18, 1963, the Supreme Court delivered its opinion. By a unanimous vote, in an opinion written by Justice Hugo Black, the same justice who, 21 years earlier, had dissented in Betts against Brady, the court overruled Betts and held that the Sixth Amendment's guarantee of counsel is a fundamental right, made obligatory upon the states by the 14th Amendment. A man too poor to hire a lawyer, the court said, cannot be assured a fair trial unless counsel is provided for him. Clarence Earl Gideon was tried a second time. This time, a lawyer stood beside him. He was acquitted. That ruling stands today. Court is adjourned.